Then we'll move to voir dire, and Justice Borleo will tell us about Batson, and I will tell you a little bit about a fun objection you can use in a rare case to jury nullification. We'll go through evidentiary objections, opening and closing statements, sentencing, and motions for new trial.
So the reason why we kind of picked these topics, because there's a lot we could cover in preservation of error, but these were kind of the things that Justice Landau and I had sat down and discussed, kind of the most common things that we're seeing that are either not preserved properly, or it's things that maybe need another step that we're not getting up at the Court of Appeals.
Because sometimes you can yell objection and holler out the correct rule number even, and it's not enough to preserve it, which is kind of shocking. There was I'll get there when I get there, but there's been some cases where I said, oh good, they preserved it, because I read the transcript, the word objection appeared, excellent, and then you get into the law and you're like, oh, that was not sufficient. That is waived, okay. Which is, again, it'll drive you to drink, honestly. Okay, so just the pitch for trial briefing is, there are some things that come up during trial that you can't anticipate, right? Some evidence comes up the day of trial, you didn't know that was out there, but there's some things that you know are gonna be an issue. If your client has extraneous offenses, you get notice of that, that's gonna be an issue. So what you can do to kind of organize your thoughts and not have to think on your feet for every second of the trial, you can type up your objections to things. You can do motions in limine. There are things that you can know ahead of time. Call your appellate lawyer friend. There's no reason to leave everything to the trial itself. And anybody who's tried a case knows how hectic it can get, and you can kind of lose track of things because there's only so much whack-a-mole any human being can play. And the trial briefing allows you to kind of apprise the trial court of these issues and preserve error all at once. Sometimes, I don't know if you've had this experience, Justice Borleo, but the first time a judge hears about an issue, maybe the judge is resistant to that issue, but as you develop your trial theme, as you give the trial briefing, it kind of sinks in, and the argument has a chance to percolate, so you don't get a reflexive no. Maybe the first time it'll be a reflexive no, but by the second or third time that issue has come up, maybe the judge now sees that letting that evidence in is actually harmful. So, in addition, do you want to?
One, I guess, little tip that I learned in practicing is if you know, for example, there's a piece of evidence you really want to get in and the state's going to push back on you or anything, maybe you've got a weird motion to quash issue where it's technically it's going to be legally technical. One thing I liked to do was bring copies of the cases that I'm relying on, but one for the judge, one for the prosecutor, an extra one just in case you need an extra one. Highlight it, tab it, have it ready, so when you're at the bench and the judge looks and says, do you have any authority for that? Well, actually, yes, I do, and here's some cases, and here's some cases. I do think that it's helpful because it not only kind of prepares you when you're working up your case, but you know what? If you may be the only person in front of the judge that has case law. The state may not have anything. And so in that case, there may be a chance that you can persuade the judge based on the case law you've brought and the argument you've made. And I think it's always good when your client also sees how prepared you are and how hard you're working for the client. So I think just all around it's a really good tone to set for your case.
And also, I think it kind of helps prevent what I call judicial law feelings, which is the judge hears a phrase that sounds right. Oh, Your Honor, the defense opened the door. Oh, I've heard that before, that sounds right. But if you have a case that shows you did not, in fact, open the door, that's much more persuasive than, nuh-uh. Okay, so here are some examples of things that you might consider preparing written trial briefing on. We're going to go into these in some detail, but we've had a debate whether it's AICI or AIC funding motions. If anyone has a definitive answer, we'd love to hear that. If you know that there are extraneous offenses that might come in, you can prepare briefing both on the Rule 404B part of the analysis as well as the Rule 403 analysis. If you have a case that where a stipulation might be appropriate if there's a predicate offense, as in a felon in possession of a weapon case. You don't want to necessarily have the jury hear what the felony was. You'll just stipulate that there was a felony. You have the right to do that. Also, failure to register as a sex offender is another example of that. You might not want the jury to hear what that sex offense was. It might be pretty bad and worse than the failure to register. You can think ahead about what lesser included offenses you might put in the jury charge. And it does really help to find a case or two where a court has found that that misdemeanor is actually a good lesser included offense for that very serious felony. And you can kind of work your way down. You don't have to just pick one lesser included offense. There might be 3 or 4, and you can decide as you go along which is appropriate and which is the best trial strategy. You might also think about voluntariness and probable cause and other specialized instructions for your case that may come up depending on how the evidence goes.
So I want to talk to y'all a little bit about funding motions. I will tell you that the most common reason I used to hear from practitioners about why they don't file a funding motion is, oh, the judge isn't going to give me the money anyways. And I had a very smart lawyer tell me once, you make that the judge's problem. Ask the judge for it, show the judge why you need it. If the judge says no, you've now preserved error for appeal. But on appeal, if you needed an investigator or you needed some sort of expert and you didn't ask for the money to get it, the only way an appellate court can even look at that is under an IAC claim. So make it the judge's problem. Make the judge tell you no if the judge is going to tell you no. And then the appellate lawyer can bring it up to us and we can actually look at it and see if you are entitled to that funding or not. That is why I think it's really important to make your funding motion. There's lots of kind of threshold things that you're going to need. So when they got into the Court of Appeals, some of our colleagues on the bench may not look at it and say, oh, that's waived because they didn't have all the steps necessary. So there are 3 factors that the trial court looks at. The defendant's interest, why do you need it? The state's interest, how much does it really affect the case? And the third is really a probative versus prejudicial. How important is it that this particular expert, be utilized in this case? One thing you also need to remember is that AICI motions can arguably apply to any type of case. I have an old AICI paper from maybe 5 years ago. If anybody wants it, I'm happy to send it to you. You can just email me. But there's kind of a list of cases that it's not just a psych expert. It's not just a drug expert. It's not just a blood spatter expert. There's all sorts of different ways you can use an expert. And if you make the threshold showing, ask the judge for it, you might be surprised. The other thing I will make a pitch for is just because the judge tells you no once doesn't mean you can't file that motion again and ask the judge again. Keep asking if it's really that important to your case. But the key is that you must show that whatever expert you're trying to get is necessary and necessarily related to a subject that will be a significant factor at trial. So a significant factor is a contested issue, and the favorable resolution of which will either directly support your theory in guilt, innocence, or punishment, or directly attack the state's evidence. I would very much urge you to file these motions ex parte and under seal, because to do a full, thorough funding motion, you're going to need to you're going to need to give the trial court a little bit of insight into your defensive theory. You're going to have to show the trial court why this expert is necessary. Now, you probably don't want the state to know that. File it ex parte, file it under seal. You are entitled to do so. You should always be doing that. The state should not know that you're asking for this money. We review anything under an abuse of discretion standard. So like I said, the more detail and the stronger your argument is as for why you need it at the trial level, the easier it is for us to say on appeal, the trial court abused its discretion in not giving you that funding. But that's kind of, abuse of discretion standard is a pretty hard standard to meet. So just keep that in mind. The more information you give us, the more meat to your motion, the easier it is on appeal for it to be reviewed.
Okay, so this may look out of order because we haven't gotten to trial yet, and we're already talking about jury instructions, but that is not an accident. Jury instructions can be a very effective tool on appeal. It's one of the few areas where you can routinely win an appeal if it's preserved properly. So I would advocate that when you start really breaking the case down for trial, the jury instructions are part of that breakdown. You might realize that the state is lacking critical evidence on an element that you would not have necessarily put together otherwise. It also helps you build your case so you know how to attack what the state is putting forward to the jury. You can also decide or start thinking about strategically whether you want to give the jury some ways out on a lesser included offense, or if you want to put voluntariness at issue or probable cause. You need to start working on building that into your case so that you can have the instruction, an entitlement to the instruction when it comes time for that. So very much in favor of not waiting for the charge fairy in the bottom of the courthouse to spit out a charge, which may or may not actually be the law, right? So don't yada yada the jury instructions. That's a critical part of your trial prep.
Yes, jury instructions, it was one of the things that I reviewed when I was at the public defender's office, and when I was first given this task, I thought, well, this is kind of fun. There's a lot of little things, and it was fun in a very kind of weird and grammatically interesting way. But look at if it's charged in the conjunctive or the disjunctive. Look at if it's a result of conduct offense. Make sure that your jury charge is tailored to the facts of your case. Don't just let them throw everything in there and kind of leave it so open for the jurors on your panel. Pull the PJC, pull the pattern jury charge. My last experience, the judges were kind of resistant to that in Harris County. Is it still the case? Over in the civil courthouse building, that's all they use is the PJC. I don't know why they don't do it in the criminal courthouse building, but those make sense. They're written so that people can understand them. I can't understand some of the jury charges that we get. I've been studying this for a long time. Sometimes I've actually had to diagram a sentence and figure out what is this actually saying here. But if you're prepared, you have your arguments for why certain language shouldn't be in there, you have a better chance of winning. And speaking of lesser included, one thing I did want to say, if the state wants to try and get a lesser included in and you don't, that's a good time when trial briefing can come in handy. If the state is going to try, for example, and I'll get into this a little later, but to go from an intentional and knowing to a reckless, there's an argument you can make as far as why they shouldn't be allowed to do that. It may not be a winning argument, but once in a while you might win it, and it might be that case that it's really important to keep those instructions out.
Another thing that's great about the pattern jury instructions is that they tend to be a little bit better with the plain English. So you might actually get a jury reading them instead of the jury just passing their eyes over it and not understanding what their job is. Okay, so basically, the threshold for being entitled to a jury instruction is surprisingly low. So that's something to remember. Don't hesitate to request and then object, and make sure you put in what it is you would want the jury to read, what the instruction should be. So it's not enough just to say, hey, can I have an instruction on voluntariness? You want to give the judge a specific instruction, put it in the record. If need be, you can say it out loud or file it right there, right? Okay, motions to quash. There are a surprising number of motions that you can use to preserve error in cases that seem a little, hard, I guess. I had a case where there was a constitutional challenge to an incest statute. There wasn't a lot of other defense to give, but that it was a surprising challenge, and it was taken seriously on appeal. You don't have to do a whole lot. to preserve that kind of error. You just make clear what the basis of the challenge is, how it's unconstitutional. You don't need pages and pages of trial briefing on it to preserve it. So it's an easy one to kind of get in there.
Another thing to look at in a motion to quash is, are all the statutory elements of your offense. Seems like a really easy kind of broad generalization, but you'd be surprised how much just kind of gets missed just from going through it. For example, on a reckless case, your indictment must allege the circumstances of the act which indicate the defendant acted in a reckless manner. It's not enough just to say reckless. But if you don't ask for it, and the state doesn't give it to you, you can't really complain about it on appeal. The continuous sexual abuse of a child, I know when I was at the PD's office, we kind of had a motion to quash on that just kept growing and growing and growing. At last count, I'm gonna say there were probably 12 or 13. This is just kind of a list generally of things that we would look at to challenge it. One of the main ones being like jury unanimity, double jeopardy. It's exposing your client to double jeopardy. It lowers the state's burden of proof because it's such a broad statute. Now, it's true that this gets litigated and you lose a lot, but if you keep if you stop bringing it up, there's never a chance that you're going to win this. And I will like to this is kind of as a general rule, one thing that's great about the criminal defense community here in Harris County particularly is that y'all are pretty tight, and you now have the public defender's office as kind of a central hub. I would encourage you all, you don't have to recreate the wheel every time when you're looking at a motion to quash. There are very, very smart people on the listserv and who practice, who, when y'all start spitballing ideas, that's how these motion to quash, like how all of our laundry list of things, how that came about. It was lawyers sitting in a room thinking, hey, how else can we challenge this? And you never know. One day, one of them might come out successful.
If some of these ideas are new to you, you might consider having as your second chair someone who's done appellate work before. I think that those teams can be extremely effective. As an appellate, when I used to do appellate work, I really enjoyed that kind of work because you get to participate in the trial. You sometimes can make a difference in the client's life when they leave your care.
I will tell you that I think before I was on the bench, we'd look at the reversal rates of civil versus criminal, and it always seemed like the criminal cases were a much lower percentage. And of course, there's a faction that we can argue that it's all harmless error, but the other difference I've seen is that a lot of these civil trials do have appellate built in from the beginning.
Absolutely.
They have appellate lawyers involved from the beginning of the process. They are preserving the error, giving the appellate court something to actually go from. So if you build it in from the beginning, you have a greater chance of winning on appeal. I'm going to talk to you a little bit about Batson. It is a case, it's something that you see frequently, and most of the time that I've seen Batson at the appellate court level, it's been pretty well preserved. I feel like sometimes the hardest part is just catching it. Prima facie case of racial discrimination, that's your first step. You've got to look and say, hey, something doesn't look right here. Then the burden shifts to the state to give a race-neutral reason. And then step 3 is that the trial court has to decide. Build your record as much as you can, because at the appellate court, we do not see the people in front of you. I do not know if the state's saying, well, they had a bad look on their face. I don't know if that's true or not. If you don't think that was true, put it on the record. Appellate lawyers, if it's still, I don't know if it's still just as hard to get the jury information sheets, but we used to routinely file motions to get the juror information cards. And my experience in requesting those, getting the order signed, if I told the trial court judge that I was an appellate lawyer and we had a Batson issue, I never had a judge really push back too hard on getting that to me. But remember that at the appellate level, we see paper. So I can't tell if that person made a weird face or didn't make a weird face. I can't tell any of these things if you don't put it on the record.
So this next part, jury nullification, is a little bit of a niche subject. It doesn't come up very often, but I've had it come up often enough where it's probably worth mentioning, particularly in a case where the trial is going to be pretty difficult. Sometimes you will get potential jurors who ask the judge questions about whether they can, in this, just applying their own conscience, find the defendant not guilty, whether they are the judge of the law as well as the facts. And the judges usually give a pretty heavy-handed response to that probably goes too far in assessing who's the judge of the law and who's the judge of the facts. And you can object to what the judge says in terms of instructing on jury nullification. Clay Conrad wrote a good book. I've briefed this issue before. It's a little detailed, but if you just think in advance what you might want the judge to say about that and what would be a legally correct instruction, and kind of have that ready in case it comes up, it can be a neat issue on appeal, particularly if it's preserved, because it arguably constitutes fundamental error, because if the jury is instructed at the outset and they're instructed incorrectly about what they are the judge of, that kind of taints the whole trial. So it's kind of a neat little objection. Okay, now we've hit trial. So improper opening, I did a little research on this because although I know in theory what improper opening is, I haven't seen too many successful cases arguing improper opening. So I guess the first thing to say would be just saying like hopping up and saying improper opening is not going to get you there. It's a great start. So just use that as a placeholder as you figure out what is improper about the state's opening. Things that might be improper that you should be on the lookout for would be burden shifting to the defense, whether the prosecution's argument is argument instead of just previewing the evidence. Does the prosecutor, for example, mention evidence that you are planning to argue should not come in? If they preview that in the opening, you can start building your story through your objections, and it can be a part of your trial theme. Does the prosecutor strike at the defendant over counsel's shoulders? That's also improper. So when you object to improper opening argument, don't stop there. Just make sure that you specify what the problem is to set it up for a good appeal. So when you begin objecting in the opening, probably the prosecution has thought about their trial theme and they're going to repeat that error throughout the trial. And if you set the stage at the opening, it also really helps your case on appeal for harm. Because it isn't enough at the Court of Appeals just to have error. You have to have harmful error. So if there's evidence, say an extraneous that shouldn't have come in, if the state highlights it at the outset, it's the first thing that comes out of their mouth in their opening statement, you can say, look, there's harm here, there's harm here, there's harm here. At every stage of the trial, they talk about it during voir dire, they talk about it during opening. There's like half their witnesses are about this extraneous offense. You have a great case on appeal that evidence, not only should it have not come in, the fact that it did come in is very harmful to the defendant and may have influenced the result of the trial. That's what you want on appeal. Okay. For folks who have been around for a while, you've probably heard this before, but I know we have some new people in the room. If you really want to make your objection have some punch, you don't want to just state an evidentiary rule. You also want to figure out how it maps onto the Constitution. And the reason for that is evidentiary errors on appeal, we only look at them for abuse of discretion, which, as Justice Borleo mentioned, there's a lot of wiggle room. It has to, in order for us to reverse, it has to be outside the zone of reasonable disagreement. That's pretty broad. But constitutional objections, if they're well-founded, they're legal issues. So we get to review them much more thoroughly. So it's if you really are certain that this evidence should not come in, object to it both by rule and by Constitution. So for example, if you want to put evidence in and you're not allowed to and it's relevant, yes, absolutely, say 401, but also say due process, because you're not getting the chance to try your case, and you're not allowed to put on your defense. Same idea, you're not allowed to cross-examine. That's also relevant, and it can go to bias or any other topic that you find in the rules of evidence, but it also is a Sixth Amendment right to confrontation. And the case law on confrontation is pretty great for the criminal defendant, less so for bias and prejudice and things of that nature that are rule-based. So extraneous offenses, I see a lot of cases with extraneous offenses on appeal, and it winds up being the tail wagging the dog. A lot of times the extraneous is so bad that the jury has the propensity to convict based on some terrible offense that has nothing to do with the case that's actually before the jury. You'll see in a tiny amount of marijuana case, all this other evidence of drugs comes in that's not really relevant because there's someone else's drugs. So you want to be very careful about that because the jury can get very inflamed very quickly with a very serious extraneous.
Bring it back to your client. What right of your client is being violated here? That on appeal is going to get scrutinized more than, oh, the judge messed up because the judge, this is under the rules of evidence, this should have come in. Okay, well, that's an abuse of discretion. I could see how maybe make it about your client's constitutional rights. That's really going to protect your issues, protect your claims.
And relatedly, if evidence exists in multiple forms, like say there are inflammatory photos about the extraneous offense, there's testimony about the extraneous offense, there's video about the extraneous offense, make sure you don't just object and then sit down and never talk about it again. Every time it's introduced, every time the jury is going to hear about that extraneous that you believe should not come in, make sure you object. Otherwise, there's a chance that you object the first time to some testimony, but you didn't object to the pictures, so there's nothing we can do about that on appeal, even though it could be very harmful. So you don't want to waive anything by making a partial objection. Okay, so this is something that I learned in the last 9 months, and it kind of blew my mind, so I wanted to share it with you. I didn't have much occasion to object to experts when I was at the public defender's office, and I was surprised when I became a judge at how specific your objection must be in order to not waive it. So they're kind of sticky. It's under Rule 702, and in a lot of evidentiary contexts, it would be enough just to say objection and then rule number, and then everybody knows what you mean. But 702 has a lot of layers, so it isn't clear to the trial court necessarily with just objection Rule 702 what the objection is to. So I'm pulling from a case that was decided recently, and we'll work on it together. Okay, so this back and forth is at trial, and the state is asking its witness, a police officer, in a DWI case, if HGN is present, can that have any effect on somebody's driving? Defense is like, I'm on it. Objection, Rule 702. Court's like, nah, overruled. So the officer answers. It could cause a difficulty with impaired vision. It could impair the vision slightly. That's the last objection we hear from the defense. The officer goes on to testify about how he administered the HGN test to the defendant, and that she exhibited 6 of 6 clues, and that as a result, the officer concluded that the driver was intoxicated. So here's the question. This is the part where you wake up. Does this preserve a complaint on appeal that the trial court erred by allowing that officer to give the expert conclusion that because the driver had HGN and failed the HGN test, that she was impaired? What do we think? No, it does not. So this sounds like it's a pretty specific objection, but if you read Rule 702, there's a lot to it. It's not specific enough. So a general objection, like Objection Rule 702, is only read on appeal as an objection to the predicate of Rule 702. So what your job is as the trial lawyer, if you know there's going to be expert testimony, you need to kind of look at 702 and figure out what the problem is. Is the problem the qualification of the expert? Is it the reliability of the science? Is the HGN test just a crummy test that no one should rely on? Or is the result of the test irrelevant? It's probably not irrelevant in this case, but in your case it could be. So you want to be specific and say, Rule 702, this expert is not qualified. Rule 702, this science that he's relying on is pseudoscience, or this science is not relevant to the issues that the jury has to decide. So objecting to qualifications doesn't preserve reliability. Objecting to relevance doesn't preserve qualifications. I think you get my drift here. So you have to be super duper specific, otherwise it's waived. Okay. All right. Okay, so before we get to closing argument, when the state rests, you want to check, does the evidence that the jury heard conform to the indictment, or is there a variance that you need to bring to the trial court's attention? And then you would move for an acquittal. But now we're at closing argument. Things to look out for, to object to during closing argument, bolstering. So if the prosecutor says, I don't know about you, but I sure think that this person's guilty, they're bringing the opinion of the state into your case where it does not belong. Their opinion does not matter. The evidence matters, the law matters, the individual prosecutor's opinion, not appropriate for discussing during closing argument. Other things to be on the lookout for are shifting the burden to the defense, trying to say like, oh, they didn't bring you anything, the defense didn't bring you anything. Not the defense's job to bring the jury anything. So we want to be careful that we object to comments on the defendant's silence. They have the right not to testify, and the state does not have the ability to comment on that during closing argument. Now, as with the evidentiary objections, you want to constitutionalize these. So if the burden is getting pushed onto you, you object to, and it's compromising the defendant's due process. The defendant doesn't have a burden of proof here. The defendant has the right to remain silent, and that is also constitutional. So make sure you get both. Oh, you also want to, one thing I didn't make it onto the slide, you want to be careful, the state may misstate the law, and you definitely want to object to that.
Never.
I know, it's shocking, I'm shocked, it happens. So you want to, and also I think it has just tactically, it can give you some credibility if you say, objection, it's a misstatement of the law, and you're right. The jury might be more inclined to go your way.
So I just want to take a minute. This is kind of a controversial issue because generally, if your sentence falls within the range of punishment, the courts are going to say it's okay. I am seeing more of these issues brought up on appeal, like a 99-year sentence for just over a gram of meth. It's a little bit, definitely there were priors, there were a whole host of issues, but it still seems a little bit unjust, I guess. So there's a case called Solem versus Helm. There's 3 factors that an appellate court will look at to review the constitutionality of a sentence: the gravity of the offense and the harshness of the penalty, sentences imposed on others in your jurisdiction, sentences imposed in other jurisdictions, obviously of the same sort of offense. Now, I have never once seen this preserved at the trial level, and even on appeal, oftentimes if you get anything, you're going to get like a 1-sentence kind of throwaway as an issue. And I do kind of get it, because historically the courts have not looked at this with any favor. There is some precedent, though, for cases being overturned because courts have found the punishment unconstitutional. A practice tip that we discovered, I actually ended up writing a concurrence to that case because it wasn't preserved, but a practice tip that I found was find out what the federal sentencing range would be. Find out what that would be, but you're going to have to preserve it at the trial level for the appellate lawyer to even have a shot at bringing it up. And I understand sometimes in the heat of the moment when you get a sentence, it's probably not the first thing on your mind. This kind of goes back to preparing stuff before the trial, getting stuff ready, just in case. This could be one of those just in case times. I have read dissents where judges have dissented to the majority saying, no, this sentence was in the range, it's fine, and a handful of cases have been overturned. So it's not unheard of, it's just not preserved. And then motions for new trial. You know, the criminal courts, you have to file your motion for a new trial, ask the judge for a hearing. In the civil courts, you file a motion for a new trial, you can set it for a hearing. So if you're bringing an argument up on appeal that you should have been entitled to a hearing, there are a couple things that you really need to be careful of. A, obviously make sure it's timely filed. B, make sure you're raising matters not determinable from the record. And the last one is that your motion and affidavit establish reasonable grounds showing that your client could potentially be entitled to relief, which sounds like a bunch of, you know, legal jumble to get courts to say, no, it was fine. We actually do look at these pretty closely, but there's another threshold here. You need to make sure that your affidavit is specific enough to get you over the threshold. You cannot rely on bare assertions or general statements. For example, if you have a client who wants to say that the lawyer didn't tell them about the plea bargain, well, it's not enough just for the affidavit to say, well, the lawyer never told me about the plea bargain. Also has to say that he would have taken the plea bargain if he had known about the offer. So make sure that you're getting all the steps in there. You know, if it's that they didn't investigate a certain piece of evidence or talk to a certain witness that would be important. Make sure you're telling the appellate courts why this person would have been important. You want the appellate courts to be reading your issue and saying, you know what, this motion, this affidavit, a judge should have seen this, a trial judge should have seen this and said, wait, there's more here that we need to explore. But if all you're doing is filing a very bare bones, you know, the client didn't like the sentence, the client didn't know about this, the client didn't know about that, that's not enough. You have to do that next step.
I think also, just to be really specific on witness who was not talked to or not called to trial, you want to make sure that you drill down and make sure that that witness would have been available for trial. If they've been living in Europe for the last 2 years, you want to make sure that you get in the affidavit, yes, I lived in Berlin, but I would have come in for the trial, because that's your burden as well. Helpfulness and availability. Okay, so now we're going to zoom kind of back out to the 30,000-foot view. How do you preserve error? If you need to object, make sure that you do so either in writing or on the record, and that you get a ruling. Sometimes the judge just keeps talking and doesn't actually rule on your motion, so make sure that if you have an appellate second chair, they can help keep track of that for you and say, Judge, what was the ruling on my objection? Or if the judge refuses to rule, you can object to the lack of the ruling on your objection. That's very meta, but you can do that. Something to remember, if something comes in as a surprise at trial, you didn't get notice of an extraneous offense or some evidence that's pretty pivotal that you need some time to review, like say a video of the scene that shows allegedly your client in it, you need to ask for a continuance, because just not getting notice doesn't get you anywhere on appeal. So if you get a surprise, you say, Judge, I need a continuance, denied. And then you want to proffer what it is you would have done with the continuance. How does that harm you? Because as we mentioned before, it isn't enough that there was an error, there has to be harm. So you have to say, Judge, I need to interview this witness, or I need to examine these records and make sure that this extraneous offense, to even see if it is my client's. If you have somebody with a common name, I would not just take it on the state's word that that is your client there. So it's not enough just to object to the lack of notice. You've got to ask for the continuance, and you also have to proffer what you would have put on. Otherwise, the appeal is a no-go. And if it is not apparent in the record what it is you would do with your opportunity if the court would have given it to you, you can file a bill of exceptions to perfect your record. So you can object, you can proffer verbally, and you can be very specific in terms of putting in the record the document you would want to cross-examine on. For example, I had a case when I was in the public defender's office, and the defense attorney wanted to cross-examine the only witness in a murder case, and the judge said, no, you cannot ask the witness about this long-standing family feud. Well, there was a police report that was relevant, so the attorney did a good job of preserving error by objecting, saying that he wanted to cross-examine this witness on this subject, and then putting in, as a bill of exceptions, a police report that he wanted to specifically cross-examine the witness on, so there could be no question on appeal what the subject matter was that the defense attorney wanted to get into. It may feel like things are very obvious to you when you are in the heat of battle, but when you're reading a cold transcript, it doesn't feel that obvious. All right.
Any questions? Do we have
I think we have a, I think we might not. Do you have a second? All right. If there's a question, yes?
Earlier on, you mentioned jury nullification.
Yes.
And you said
Making you work for it.
okay, earlier on, you had mentioned jury nullification. And jury nullification, most judges don't. And you mentioned, well, there's a case, it's really a neat objection. What was it? What are you talking about?
Oh, there was a case in front of the 14th Court of Appeals, and I'm struggling to remember the name. That's probably why I glossed over it. But what I would do is I would read Clay Conrad's book. He talks about the history of jury nullification and what the jury has the right to rule on. So I don't have it condensed to a neat thing, but if you give me your email address, I'd be happy to send it to you when I do.
Judges will be very heavy-handed about jury nullification, even threatening the trial lawyer with consequences.
Right, and you can parlay that into a successful objection.
Okay, I'll give you the number.
Yeah,
Thank you.
absolutely.
Sure.
Check. 1, 2.
Turn on the mic.
Good afternoon, Justices. I don't know if this is working or not.
I don't think so, sorry. I'll repeat what you say, how about that?
That's fine. I don't think it's necessary. I'll just get on with it. Early, we were discussing jury charges, and you mentioned the pattern of jury charges. And there's some folks who might not have been doing this so long and who don't know that there is a distinction. You're talking about, I presume, the Texas State Bar's
Yes.
pattern jury charges. However, there is a competing bank of jury charges used in Harris County by the court reporters.
Correct.
And they can be found on the
Chargeberry.
county's website. That is a great repository of outdated law, tortured grammar, and confusion. So
Yes, sir.
I just wanted to make sure everybody's clear on that. Don't go there.
There's actually a CCA case, and I think the language.
Oh, I know this one.
Yeah, Judge Cochran calls that part of the jury charge legal argle-bargle, because it is, the Harris County Charge Bank is very, very difficult and unwieldy. So yeah, if you haven't actually read the pattern jury charges put out by the State Bar, I would highly recommend you do so. They make sense. You can read them and understand what your case is about.
And if you don't know where to find that, you can find it at the Harris County Law Library, among other places.
Okay, we are lawyers and we can go on for a minute, so we're going to take one last question and then we're going to move forward.
On closing argument, the state commonly, on opening of closing argument, they'll waive open and reserve right to close.
Yes.
Isn't that shifting the burden if you're not allowed, now imagine this would ameliorate the abuse, if you're allowed to respond to their closing argument, but when they waive open and reserve their right to close, isn't that shifting the burden?
That's really interesting. I had not thought about that before. I think you should object to that.
Try it and see what happens and see what the appellate courts say. I've never actually even seen that objection made. That's pretty interesting.
Well, I have one state's attorney who got so discombobulated with that, he kind of blubbed it and I think he lost the case on account of that, but they waived their right to open, and they reserved their right to close, and it just seems to me like they shift the burden.
That's an interesting idea.
All right.
Well, thank you all very
Thank
much. It's
you.
been a pleasure to be with you.
As our next speaker makes her way in, I want to thank Justices Landau and Borleo once again. Allison Mathis is a public defendrix in Harris County, Texas. She is also a book snob, a wine equal opportunist, a good cook, but and a bad singer. Now, I would agree to that. She collects teapots, witty intellectuals, which is why I can't get away from her, and mugshots of famous people. Before she was a lawyer, she was a cake decorator, aspiring literary critic, and superlative diner waitress. Prior to joining the Harris County Public Defender's Office, she held positions as an assistant public defender in Aztec, New Mexico, tribal advocate for the Swinomish Indian tribal community in La Conner, Washington, and chief public defender of the Republic of Palau. So she's well-versed in exotic things. Just check out her clothes if you question me on that. She lives with her darling daughter, Julia, and her husband, Mike, and their 2 goldfish named Orange Julia and Karen. So please welcome Allison Mathis.
So I guess I didn't get the memo about the PowerPoint template. Mine looks different than the last couple of ones we had. So this is about motions drafting, and I guess I kind of think of practicing the law. I kind of thought of law school as going to Hogwarts, right? I'm a little bit witchy, and I guess when I came home from one of my first classes, my ex-husband said, "What did you learn at Hogwarts today?" And I said, "What do you mean?" And he said, "Well, I just kind of imagined you like learning about all of these like weird Latin turns of phrase that make courts do something, right? Like hocus pocus." So the origin of hocus pocus is actually kind of interesting. It comes from liturgical Latin, hoc est corpus, right? This is the body. But it gets garbled by hundreds of people who don't really read Latin and don't really understand Latin, but who have sat through these liturgies for hundreds of years, and they just know that words are powerful. And so hoc est corpus becomes hocus pocus, and it loses all of its original meaning, and it just means magical words, right? And so I think that's kind of interesting when we're talking about legal writing, because I think especially trial writing has gotten really, really garbled and moved away from all of these. It's too focused on all of these magic words, and it becomes intimidating for trial lawyers. And so I've practiced in a bunch of different jurisdictions. And I think one thing that's common to all of them is that motions practice is becoming a dying art, and it's a huge problem. And I think that it's a weapon that we all need to have in our arsenal as we move through trial, right? And I think there's a lot of reasons for that. I think in Harris County, this is one of the biggest jurisdictions in the United States. We have a huge criminal defense bar. There's no reason that we're not leaning on each other to be filing great motions. I've heard a couple of really wild horror stories lately about stuff that's happening in the courts. Recently, one of our attorneys had filed a spat of template pretrial motions. The prosecutor didn't even read them. And the judge said, "State, do you have any objections to these motions?" And the prosecutor said, "I guess not." And so the judge just granted them all, right? everything in the motion in limine just granted. That's amazing. This is the time we need to be filing motions, right? So that's kind of my introduction to what I want to be talking about here. So I also wasn't sure kind of where everybody is. I've been talking to a bunch of different lawyers here in Harris County, and I think a lot of people are not really even understanding what they're filing when they file it, right? There's a difference between a motion and a notice or a request. And I didn't think this was necessary until I heard the other day about a judge who had written an order granting a notice. So I mean, that doesn't make any sense procedurally. And so I kind of want to just like talk through this because they don't teach this in law school. And this is one of the most important things we do as lawyers, right? So motions are when we're asking the court to move. We're asking the court to do something, and we attach a certificate of service and a specific proposed order. And I'm going to talk a little bit about this because the more motions that I look at from other attorneys filing in Harris County, the more I see these proposed orders are vague and not specific, and they just, at the top, they just say order. It doesn't even say, it just has the caption at the top and then it says court's order. It doesn't even say what the title of the motion is. It could have been attached to anything. And I think that's lazy. And we're not getting everything we could be getting out of those orders when we're not drafting them specifically. Notices are telling the court that we already did something. That's why it doesn't make any sense for the court to rule on a notice, because they don't have to do anything. We're not asking them to move. You put a certificate of service on a notice, but you don't put a proposed order. So the way that I want to talk about this is a notice of demand for a speedy trial versus a motion for dismissal for a speedy trial violation, right? For some reason in Texas, we are not filing notices of demand for a speedy trial. That's one of the things appellate courts look to when they're trying to determine whether or not there's been a speedy trial violation is, did you demand and when did you demand the speedy trial? In other states, there's an automatic period of time that starts running depending on the state, depending on the jurisdiction, from when you get arrested, from when charges are brought. But in Texas, that's not the case. We have to demand a speedy trial, and there's no reason that we're not filing a boilerplate demand for a speedy trial saying when your client got arrested, whether they've made bond, and how this is prejudicing you to not have a speedy trial. There's no reason we're not filing that into the case. And this is the notice that I was saying a judge actually ruled on. And it was in our favor, right? The judge ruled on a notice for speedy trial by dismissing the case for speedy trial violation. But it still was improper procedurally. So once you make the demand for speedy trial, then you wait and wait and wait, and your case doesn't go to trial, and you file a motion for dismissal because of speedy trial violations, right? And so that's when you're asking the court to do something to dismiss. So with motions, I want to talk a little bit about just kind of how motions should look and how they should work, because I think a lot of people, like I said, law schools don't talk about this. So I like to try to keep motions pretty short. I think they need to be about maximum 2 pages long. Set out the relief that you're asking for, or in the alternative, ask for a hearing and be specific about the relief. Personally, when I'm drafting a proposed order, I never give the judge the option to deny my motion. I think a lot of people do in boilerplate orders, proposed orders. They just have like a little box that says check here for granted, check here for denied. No, absolutely not. If the judge wants to deny my motion, they can draft their own stinking order, right? They can't just check a box on mine. So one of the things that happens sometimes is I think that a judge could decide based on the motion that I'm filing and based on a responsive motion the state is filing. I think the judge could probably decide based just on the motions, any attachments to the motions I might have, or the case law in the motions that I'm citing. But I still might ask for a hearing just because I want to be able to elaborate on it, or I think, maybe this is kind of my last ditch effort. one of my other kind of tricks as a sort of beleaguered public defender, not so much in Harris County as in other jurisdictions that I practiced in, is if I didn't have time to fully brief an issue before I ended up going in for a hearing, I would make my argument to the court, and then I'd ask the court for leave to brief afterwards if I felt like the court didn't really understand what I was saying, or if I felt like the judge was about to rule against me. You can kind of just pop up and say, Judge, before you rule, I'm just asking for leave to brief the court, right? I'm just asking for leave to brief the court, just give me 2 weeks to submit a brief. And that kind of gives you one more bite at the apple, I feel like. And also putting forward that you're willing to put in that kind of effort. So like I said, I think that we need to be putting specific proposed orders granting our motion. One of the things about being specific that I think is really cool is that we can put all kinds of neat stuff in these orders that we're not even thinking about and the state's not even reading, right? One of the motions that I've filed frequently, and it hasn't been granted in Harris County yet, but I'm keeping my fingers crossed eventually, is a motion to have the state respond to all pretrial motions in writing. So, I mean, it doesn't have to be something that's based in law, right? I mean, there's not an appellate court in the world, even with justices, with Justice Landau on it, that's going to overturn a case because the court denied my motion to have the prosecutors respond in writing to all my motions, right? They're not going to overturn a case for that. But at the same time, I think that's only fair. I mean, I think equity says we need a clear record, and it makes a clear record when the state responds in writing, and we don't just, have to hope that the court can find a court reporter when we have this huge understaffing issue in Harris County. We don't need to have it. We don't need to have a hearing necessarily. Just write out all of these, write out your answers to all of my motions. One of the other, excuse me, I'm sorry, I'm getting over a cold. One of the other motions that I think we should all be filing probably at the beginning of all of our cases and not wait until the 2801 deadline, one of the things that I think we should be filing is a motion to preserve field and rough notes of the investigatory team, right? They have all kinds of notes that they're not disclosing to us. The police officers take their little memo books when they go out to the scene and they take a bunch of notes and stuff, and we're entitled to all of that, and they're not preserving it. We need to put in a motion at the beginning of every case and get it signed that says that the state needs to verify to the court that they told the police officers to preserve those notes. So when you write a specific order, one of the things you can put in that order is, I want the state to come back to the court within 10 days and say to the court, I called all of the investigatory agencies and told them that they need to preserve these notes in this case. There's no reason we're not doing that, other than laziness, right? We just need to do it. And so, I mean, I think that even when stuff like this gets denied, when it gets denied, even if it's not the kinds of motions that make or break a case, I think one of the things that filing creative motions like this does is it makes judges feel like, I can't keep denying this over and over and over again, right? They're not like outrageous motions after the judge has heard them a whole bunch of times. The other thing is, our clients love it. When I file something called a demand for anything, my clients think I am the best, right? They circulate stuff around the jail because I'm demanding that the state do X, Y, or Z. I'm demanding that they have their right to a speedy trial. They love to get big, fat packets of motions. And I think that that's a really important thing to consider as far as like client control, as much as I hate to use that term. But I know one lawyer who was, got in a lot of trouble with his client because his client felt like he wasn't working on the case for him, and I feel like he could have been filing a lot of these early motions and the client would have been thrilled, right? And it probably would have prevented him from being grieved. So the other thing is, the Code of Criminal Procedure 2802 entitles us as defense attorneys to open and close arguments on our pleadings. That's a really big deal, right? That's something that's unique to Texas. We're not taking advantage enough of that. I get to open and close. The state doesn't have the right to rebut me, right? I need to take advantage of that, and that's the other reason that we need to get in there first and file a bunch of motions. Okay, so that's kind of my whole thrust of this, is that we need to not be defeating ourselves before we even fight the battle. I know that there's this whole feeling in Harris County that the judges aren't going to grant them, the judges aren't going to read them, so why should I even bother to file them if I'm just going to get denied? But the thing about it is it's never going to happen if we don't try, and this takes a very little amount of effort. So notices, this is Martin Luther and the pounding on the church door, his 95 Theses. So notices are when we get to demand things. And I really like using that language. Language is a really big deal to me. And I like using demand when we're talking about things that we want for our clients, right? I'm demanding my speedy trial. I'm demanding my discovery. I think it's really powerful and strong. So 3914 doesn't require that you file a motion for discovery, right? It just says that you have to request discovery. And so that's what this notice is. 3914 means that you can send the prosecutor an email, and that's sufficient. But we need to be filing this stuff into the court record so that there's a record of it, right? That's our whole job as attorneys, is to preserve the record, to be records keepers. The other thing that I think I never see here is for people to be memorializing the receipt of the discovery that they have. And I think that there are some issues with that here, and part of them have to do with the portal. I think it's really hard for us to print out everything that we got off of the portal, especially if it's a whole bunch of JPEGs or long file names and stuff. But we need to be doing it, and we need to be writing a letter to the DA saying, hey DA, this is what I have as of this date. I'm relying on this representation that this is complete discovery. I'm relying on this representation that this is complete discovery to prepare for trial, which right now is set for next week. And I just want you to know that I'm going to object to anything else coming in because you haven't turned it over yet. And you need to file that with the court. Okay, so the rest of this presentation, I kind of want to focus on legal writing and demystifying some of kind of the hocus pocus, right? Some of the things about legal writing that I think have prevented good lawyers from becoming great lawyers. And I think that there's this misconception kind of that you can either be a book lawyer or you can be the kind of lawyer who advocates in front of a courtroom. And I don't think that's right. I think I've especially heard here in Harris County, I'm not a book lawyer, I don't do that kind of thing, I don't really file motions. I mean, I know that there are people who I've talked to who said that they traditionally, in a case that goes to trial, will file 2 motions. And I don't think that's acceptable anymore, right? It shouldn't be acceptable. We're all better than that. So one of the movements within legal writing is to make legal writing more clear and more concise and less mystified, right? And that's what I want to empower you to do. It doesn't have to be something that's reserved only for book lawyers. It doesn't have to be something that's reserved only for appellate lawyers. But if you think that legal writing is not part of your job as an attorney, you are wrong. It doesn't have to be the kind of legal writing that's been historically, kind of held up, but you do have to draft legal documents. So I'm kind of a history person. And so one of the things I wanted to talk to you guys about is all these Latin phrases that I think have kind of come to be one of the things that intimidates people about legal writing. When they read legal writing and when they think about legal writing, people think about Latin. Whether people are lawyers, law students, or just lay people think about Latin. So the origins of all of these Latin phrases in English law kind of comes from this concept of natural law. And so this concept of natural law, if you think back to the founding fathers and what they thought about law, they thought that all of these little cutesy Latin phrases were just so old that they were probably true, just like inherently true. We just all know these things to be true. And so I'm not going to read the Latin parts of them, but these were calls, these were appeals to authority. And so basically, courts would cite these Latin phrases when they didn't have anything else to base their opinion on, right? And I think the thing that's interesting about them is some of them are really useful. No man shall be condemned unheard. No man at the point of death is presumed to lie. We still have that, right? It's a hearsay exception. That's dying declaration. It is in the interest of the state that there should be an end to litigation. I don't really like that one, right? And then there's some that even contradict each other. The king can do no wrong. The law must not be violated even by the king. Which one is it, right? I mean, so I think when we see these Latin phrases in decisions, or when we see these Latin phrases in legal writing, what we need to see there, what we need to see is not intimidation, but the fact that they didn't have anything else, right? So the last one is a quote from Horace, who is a Latin poet, and he says, "I throw my inkwell at these 1.5 foot long words." So I encourage you to use that the next time you see something in Latin. The other thing that I think is really interesting about this is that there was a study done in the late 90s that actually said that Latin in legal opinions was increasing and had increased in the last 40 years. I think that's something we need to rail against, right? I think we need to make legal writing a lot more accessible. And that's what I want you to be part of this first wave of doing. So one of the other things that I think legal writing suffers from is redundancy. This is the Bayeux Tapestry, which is a weaving that was done about 1070 and AD. And so in 1066 AD, the Norman French conquered England. And what happened was that they took over the government and they took over the courts. And so when the conquerors are holding court, and they're holding court over the Anglo-Saxons, a lot of the legal documents and legal turns of phrase they started to use were redundant, because one word would be in French and one word would be in Anglo-Saxon or English. So we get things that are redundant for no reason now, like to aid and abet, or free and clear, or will and testament. Like will is the Anglo-Saxon word, testament is the Norman French word. So these are just ridiculous, antiquated redundancies that we don't have any need for anymore. So this is the kind of thing that I'm saying we need to move away from this crusty, inarticulate stuff. And I think we need to move away from things that are making the law sound like this immovable old white man, right? Writing is revolution, and it always has been. And bringing different voices into writing has always been revolutionary. And that's what we're called to do as advocates for our clients, is to make their voices heard. And my client's voice cannot be heard in this old, 2,000-year-old white man voice. I need to be able to speak it differently. I need to be able to revolutionize the law. I need to be able to blow up the law on behalf of my client. So like, I tend to think of, this is my mom. I know she looks really good. She's barely old enough to have a daughter my age. But I started several years ago writing to my mom. And the reason I started writing to my mom is that she's really smart. She graduated from high school. She started college, but she didn't finish. And she knows she's really smart, but she is not law trained. And she is very sensitive to law-trained people like me talking down to her. So I think this is the voice that I need to have when I'm writing to judges. And my legal experience has been pretty diverse. And so I've practiced before judges who are not law-trained, which is sort of unusual. But now that I'm in Harris County, I'm sort of realizing that that the non-law trained judges that I practiced in front of in New Mexico were considerably more knowledgeable about the law than some of the law trained judges who are here in Harris County. Because they try. I also could assume in every other jurisdiction that I've practiced in other than Harris County that by the time I went into court for a motions hearing, the judge had read my motion and my brief, which I can't assume here. In fact, I can assume the opposite here, which is embarrassing. But anyway, so that's the kind of tone that I try to have, is I need to explain this to somebody who's not law trained, but I can't talk down to them. I don't want them to be looking for a reason to overrule me because I'm talking down to them because they think that I'm, this young female attorney who's telling them how things are, right? Don't use words you don't understand, or no one else will understand them either. I teach paralegal classes, and I make them draft a bunch of template motions, and this is one thing I see all the time, is that they try to make motions sound legal, and they don't know what the terms mean, and nobody else knows what they mean either. So that's what I'm telling you to do, because I see attorneys do it too. They use words, they don't know what they mean, they just feel like they should go here. Or they go on the listserv and they crib from somebody else's motion and they don't take all the old artifacts out of it, right? How embarrassing is it? Your client is sitting in the jail, he has nothing else to do but read the motion that you send him if you send it to him. And he's looking through and the pronoun is her, because you didn't delete it and change it. Or it doesn't say the right date that he was arrested, right? I mean, like, those are just the small things that we can do. Printing it out and reading it before we file it makes a huge difference. Also, make sure to use spell check. I saw a presentation recently where somebody had misused apostrophes, and this is just like my little personal thing, and I probably got it from my mom, but like, apostrophes don't mean plural. They mean possessive. And so, like, I don't know what people think the rules about apostrophes or commas are, but if you spend about 15 minutes looking them up on the Google machine, I think that your writing will be forever improved, and people won't be looking for a reason to nitpick you, right? It's like my mom said, people always notice your hair, your eyes, and your fingernails. They notice your apostrophes. They notice your commas, right? So I think a lot of trial attorneys are especially intimidated by any kind of longer legal writing, like a brief. So when I'm talking about briefing for trial courts, I don't want you to be intimidated. So while I said that I think motions should be limited in criminal cases to about 2 pages, I think briefs should be limited to about 10 pages. Part of the reason you want to do this is because when you're arguing in front of a judge and you're giving them a string of legal citations, they're not listening to you. You are invading their only time to play Candy Crush that they will have that morning. So you need to have it all written out. The other thing is, I don't trust my memory nearly as much as I trust my ability to sit down and write something out. So I really encourage you to brief. One of the things that Hemingway talked about when he talked about writing novels was he said, always stop when you're going good and don't worry about it until you start to write the next day. That way your subconscious will work on it all the time. But if you think about it consciously or worry about it, you will kill it and your brain will be tired before you start. So I think this is really important when we're doing briefs writing. And it's something that has really helped me a lot in all manner of legal writing. Because what Hemingway is telling you is, stop for the day when you know what you're going to write about next. So when you come back to it the next day, you already know where you're going to start. You're not going to be frozen, right? You already are going good. So you know what the next section's going to be. And when you leave and you think about it, don't have it be at the forefront of your mind. Just process it. Just let it process in the background, right? Just sleep on it. don't, try to write this in a furious evening. And I think that's been really good advice for me. I think it keeps you from getting stuck if you stop when you know what you're going to write about next. So kind of my last pointers are that I think it's important that we use natural language. I think one of the things lawyers shy away from is adding emphasis to the text. We need to remember that judges are, if they're going to read this at all, probably going to skim it. And so I think it's okay to bold, italicize, underline, even highlight if you want to, certain text that you think is important for the judge to read. I think it's okay also to draw from other interesting and relevant sources. We don't have to just talk about legal cases, right? I mean, that's not everything that decides a case. We can talk about art, we can talk about literature, I have a big Bartlett's famous quotations on my desk, and I use it all the time. We need to make legal writing interesting again. And I think the most important thing is that we're unimpeachably truthful. I think that's one of the biggest problems that defense attorneys have, is that, we don't get to make the evidence. And of course, we want to massage it to be persuasive, but we also need to be careful that everything we say is unimpeachably true. And if you have to pick between being interesting or being persuasive and being truthful, always pick truthful. And I think that that's a big lesson that probably all of us have had to learn. So the last thing that I want to tell you guys is that even after your motion gets denied, it's not over yet, right? We need to be asking for findings of fact and conclusions of law. Judges hate this. They hate it because they're lazy, and this means they're going to have to probably write something. But in Texas, we have a right to findings of fact and conclusions of law when there's a suppression hearing. I don't think we have a right to it at other times, but I think we still need to ask for it. Because appellate courts aren't going to assume that the judge was wrong in their legal reasoning. But if the judge says on the record, even if you can just get them to do it verbally, what their wrong legal reasoning was, then all of a sudden you might have an issue. So I think it's really important that we don't just stop after the motion gets denied. We need to ask for findings of fact and conclusions of law. Okay. And then this is my contact information. If anybody ever wants any help looking over motions or briefs or anything, I'm super glad to give you my humble opinion. So I know we're coming up against a break, so I will cede the rest of my time.
All right, so we do have a break. We do have a break, about a 15-minute break, but I think Allison ended a little early. Do y'all have any questions for her? No? Okay. So I'll see y'all back around 2:45. What was actually interesting. Even the historical stuff. Even the historical stuff. Like, I was like, oh, great. We have a weird I know. We're growing up here.
Just anything that gets us, and they just
Yeah, they're all done.
I'm going down.
No, man. You know, I could do 45 minutes.